Chief Justice Charles T. CANADY presiding.
Good morning and welcome to this session of the Florida Supreme Court. There are two cases on today's docket, the first of which is Thourtman versus Jr. I recognize counsel for the petitioner.
Good morning, Your Honor. John Eddie Morrison on behalf of Brandon Thourtman. If I may reserve 5 minutes for rebuttal.
Certainly.
Thank you, sir. I believe that the procedural history in this case shows the underlying constitutional problem. Mr. Thourtman was held for basically a month on nothing more than probable cause, held without bond. And this is not unique to his situation. This also happened to Mr. Moore, the case that was before him. Again, state shows probable cause. State never showed proof evident presumption great. Sat in jail without bond, awaiting an Arthur hearing, which eventually, when it occurred, the state could never meet its burden of proof. That, I believe, is in
counsel, let me, and I understand what you're saying, and I think this is a significant issue, but let me ask you this. As a practical matter, for the most part, isn't this pretty much a tempest in a teapot? When we and understand this important issue about how we interpret the first sentence of Article 1, Section 14. But in light of the second sentence there, which allows detention when if no conditions of release can reasonably protect the community from the risk of physical harm to persons or assure the presence of the accused at trial, and so on. Aren't there many of the circumstances where the first sentence might come into play that would more readily be covered by the second sentence?
There are certainly cases where there would be an overlap. I believe that obviously there's two exceptions to the right to pretrial release, and this is what the rule should be. When the judge gets the case, the judge sets a bond unless one of two things is true. Either one, the state has met the burden of proof evident presumption great, or two, they have filed a motion for pretrial detention. In Mr. Thourtman's case, in Mr. Moore's case, in many cases, the state does not file a motion for pretrial detention, and they cannot meet their burden. So Your Honor is correct. There may be cases where both exceptions could apply. There are cases where one or the other would apply, the obvious exception.
Well, let me ask you this. The evidentiary issues associated with the second sentence there may be less complex than those associated with the first sentence.
I'm not sure I would characterize it necessarily that way. And Your Honor, just based on my experience, I see the state being very reluctant to file motions for pretrial detention. I have seen very few of them in my career, which indicates to me that the state considers them to be something that they would think about and think very thoroughly about before filing. So I don't have any particular reason to believe, and perhaps the prosecutor could answer that better, which one is easier. They're simply different standards with different purposes. The second sentence is forward-looking. In other words, either future danger or future flight or future tampering with the integrity of justice, tampering with witnesses, etc. The first sentence is backwards-looking. It's, does the state have enough evidence to remove the presumption of innocence, which otherwise, per Arthur, this whole first sentence is about the presumption of innocence. Does the state have enough evidence to remove that presumption? That is a wholly different issue for a different purpose. I believe that the first sentence is more about fairness. Why should someone essentially be able to have their jail sentence cut just because they're rich enough to be able to afford bond? Whereas other clients who are less rich would have to be sitting in jail. I think that's the nub of that first sentence is backwards looking. What can the state show about the presumption of innocence? Is it, do they have an...
Excuse me. Can I go back and you said that as a practical matter, you see very few motions for pretrial detention. And I'm just curious, I mean, I was a circuit judge in a very busy circuit, and we had, most of our cases are processed in Florida in very busy circuits. So it's not unusual to start at 8 in the morning with 200 cases that you have 3 hours for. And it just, given that context, it's just, is it really surprising that the state hasn't had time to show up at initial appearance with motions for pretrial detention in every case where it would be warranted?
Your Honor, I believe that the rules take that into account. I believe that all the state has to show up with is an announcement that they intend to file a motion for pretrial detention. So,
and are you saying that you don't see that very much, or that you don't see the motions very much?
I don't see either very often, Your Honor, candidly. Now, I'm sure this varies from circuit to circuit, from state attorney to state attorney, but candidly, I mean, it seems to be that the state takes those seriously and files them in appropriate cases, but not sort of on a blanket, willy-nilly, for lack of a better word, basis.
And then let me ask, oh, go ahead.
No, go ahead, finish.
The opinion from the lower court indicates that you agreed at oral argument that the constitutional text silence regarding the timing of the hearing meant that it had to occur within a reasonable time after initial appearance. And was that concession made?
First, that was not me. That was a different attorney for the office, who's now an assistant solicitor general. The concession was, and it was in the context. It was in the context of an Arthur hearing. Usually and often will take some time to put on, and that is fine, because, as I said before, an Arthur hearing isn't an exigency. It isn't a looking forward, it's a looking backwards. And the state would have to meet their burden of proof. And so in that context, the question is, wouldn't that take some time? Yes, of course that would take some time. Mm-hmm. That's not inconsistent with our position that the plain text of the Constitution says that until the state removes that presumption of innocence, until the state meets their burden of proof, the person has a right to reasonable conditions of pretrial release. And we understand reasonable conditions of pretrial release can be based on the charges, which in these cases would necessarily be serious charges, based on the priors.
There's something, I mean, it seems just only natural, and you seem to suggest the same thing in your answer, that because of the silence and because it takes time to muster proof, and we have this probable cause procedure called initial appearances that happens sometimes immediately after, but within hours or, certainly less than a day from the arrest, that it has to be a reasonable time, within a reasonable time after arrest. And so, or the other alternative would be it has to be immediately upon arrest. One or the other, but what I'm struggling to find is a reasonable interpretation that would say that you have to do an Arthur hearing light immediately, but the real hearing within a reasonable time. I mean, it's like it would either be given the silence immediately, which doesn't make sense, or within a reasonable time. Would you agree with that?
No, on two accounts. One, I don't see silence. When the clause says unless, that is a condition precedent. That means unless the state has already proven it, you have a right to pretrial release. So I don't see the silence, first of all. Second,
so I mean, if you took that sort of literally, that would mean then that at booking into jail, the state would have to be prepared for an Arthur hearing because they couldn't hold him for any period of time without bond?
I do not, booking into jail is an executive function, Your Honor. I do not believe this is about the presumption of innocence. That is a judicial function. So the question is when the case comes before a judge, not before that executive function. That's Fourth Amendment and the state equivalent of Fourth Amendment issues, which is.
Let me ask you something. Just as a former circuit judge in my county, Palm Beach County, all judges take turns doing weekend first appearances. So if you've been a judge, I was a judge for 13 years, you had a few of those just rotating around. So done a lot of these, and as a big county, so you walk in there at starting at 8 or whatever time, and then you hear everything from shoplifting to murder. People who've been arrested just the night before, whatever. So the Third DCA, going back to what we're here for, the Third DCA called it a preliminary Arthur hearing of first appearances. And then we will follow up with the subsequent full Arthur hearing. So let's talk about this preliminary so-called Arthur hearing. The judge at first appearances walks in, at least I did, and most judges I know did. And we get there about an hour and a half or so ahead of time. And the clerk will hand us all the probable cause affidavits for everyone that's going to be there that day. And I would sit there and read them all and decide, make notes on them as to which ones there was probable cause and which ones there wasn't. And I'm talking probable cause affidavits for anything from shoplifting all the way to murder. So we read them all. Obviously, the probable cause affidavit for a shoplifting is typically written by the arresting officer at the scene. Is like maybe one paragraph. The probable cause affidavit for a homicide case is usually typed 4 or 5 pages long. So the judge reads all those and makes a decision as to whether there's probable cause or not. And there is a provision, I believe, in the rules of procedure, where if the judge finds there isn't probable cause, the state, if they ask, are afforded additional time to come up with it. So typically the person is brought back the next day. And by that time, the prosecutor would have contacted the officer in charge, whatever, and a revised, amended affidavit is filed that would contain an answer to the judge's concern about probable cause. So there is that. So when we're talking about a homicide case, as opposed to a shoplifting case, the process is the same. The judge will read the PC affidavit file for his arrest and make a determination if there's probable cause or not, because the judge has 2 duties of first appearances. There may be many others. One, is there a probable cause? And 2, deal with the issue of bond. So in this particular instance, the only thing the judge has to do in this, and I'm quoting the Third DCA preliminary Arthur hearing, the only thing the judge has to do that's different than he or she would do in any other case is that at the end, the judge would have to basically recite into the record, if there is finding of it in the PC affidavit, that the proof of guilt is evident or the presumption is great. That's the only difference. Now, according to the Fourth DCA, the judge can make that finding from, I think they said that in gray, the judge can make that finding from an affidavit, such as a probable cause affidavit. So is there any reason why that can't be done? And again, as in any other case, if a judge reads that PC affidavit and he finds that there isn't sufficient evidence to show the proof of guilt is evident or presumption is great, he can afford the prosecutor an opportunity to bring the case back again the next day, like any other case, for the officers to add whatever facts are needed that are obviously there to answer the judge's concerns. Isn't that the procedure that you see? Okay, it seems to me that we're talking about this onerous long hearing, and it's not.
2 answers to that, Your Honor. First, the idea of a preliminary versus a final full hearing. That is something the state has always been charging us with, but that was never our position. That's what the third DCA said about our position. That was never our position. Our position is there's an Arthur hearing. Whenever the state puts on their burden of proof, be it at first appearance, be it later, doesn't matter. That is when the state. Your Honor has suggested that there are times when the state could marshal its evidence at a first appearance or say the next day. Still within the time that can be held under the 3.131. That may be, in many cases, at least in my circuit, that's not really what ends up happening. And that's why the representations were made down below, is that the state usually needs more time than that. But all of that is a position that the defense doesn't take a position on. It's the defense's position simply is before, unless, to use the word from the statute, the state meets its burden of proof, the judge sets a bond. And that's the constitutional standard. That's the plain language of the standard. That's what Arthur held. Very simply,
Counsel, you are into your rebuttal time by about a minute. You may queue if you wish, but you just need to be aware of that.
I thank you, sir. Arthur held is based on the presumption of innocence. The presumption of innocence applies throughout the case. To reverse that, the state needs to present evidence. Where and when they do that is the state's decision, not the defendant's. I will reserve the remainder of my time. Thank you, Your Honor.
Thank you. Counsel for the state.
Good morning, Mr. Chief Justice, and may it please the court. Asad Ali, Assistant Attorney General, on behalf of respondents. I'd like to begin by addressing Mr. Thourtman's claim. If we're understanding his claim correctly, it's that if the state does not prove this proof evident presumption at first appearance, which he admits would be the first opportunity to present such a proof and establish it, then the defendant would be entitled to pretrial release. I don't think that the plain language of Section 14 nor this court's prior opinion and author support that position. And if I may start with what Section 14 says, it clearly says that unless charged with a capital offense or an offense punishable by life imprisonment, and the proof of guilt and the presumption of great, and the proof of guilt is evident or the presumption is great, every person charged with the crime or violation shall be entitled to pretrial release. I think the problem with Mr. Thourtman's position is he's skipping this determination and sort of grouping this category of people in to the group that are entitled to pretrial release. And having the burden undetermined is different, than the proof not being evident or the presumption not being great. So if we were to just view the plain language, in isolation in and of itself, I don't think it supports that holding. I think that if the proof isn't evident, if it's still a question that's open, I don't think there.
We said in author, we said, we hold therefore that before release on bail pending trial can ever be denied. Those are the words we said in author. I mean, ever, I guess, includes first appearance.
Correct, Judge. And I think going to this court's opinion on author, I think it's important to clarify the facts and procedural history which author arose. Author followed an evidentiary hearing that was triggered by the defendant author filing a motion to set bond after first appearance. And I believe that court's exact sentence, what it was referring to, is the outright denial, the losing the entitlement to pretrial release. It's a precondition that this court established that the state must meet that burden before it's lost as a right. But it didn't address, whether someone could be temporarily detained and if that burden is undetermined. If it's undetermined and someone is being temporarily held, to make a determination, a proper determination, which, would occur at a hearing subsequent to first appearance. I think it's important to.
Let me ask you something in relation to my long-winded question, which is basically, simply put, can the question of proof of guilt is evident or the presumption is great, can that be proven by something other than live testimony, such as affidavits, deposition, transcripts, and so on. Let's say that we had a full Arthur hearing, and the state walks in with no witnesses. Judge, I want you to rely on the sworn probable cause affidavit of the arresting officer. And in there, he says the defendant confessed, the defendant's DNA was found, his fingerprints were found, so on and on and on. Can a judge, just based on that affidavit, make that finding of proof of guilt being evident and the presumption great?
I think in the hypothetical Your Honor posed, I think that a judge certainly may, and I think this court's opinion and author, when it referred to transcripts and affidavits possibly being sufficient to establish that burden, I think in that situation it may. But as far as establishing a sort of bright line rule, I just think it would be fact specific for each case. But in Your Honor's hypothetical, it may carry the burden.
Well, we didn't. Isn't it the case that in Arthur, the court said that not only is possible, but the state can probably carry this burden by presenting the evidence relied on by the grand jury or the state attorney in charging the crime may be presented in the form of transcripts or affidavits.
Correct, Judge. This court did state that, but as far as making an accurate determination of whether the proof evident presumption great burden has been met, I think it's important to follow up with what the court expressed in Arthur. In addition to the state's evidence as to what they present, the defendant is entitled to present his own evidence to rebut what the state presented. He's entitled to present witnesses and evidence in support of even obtaining pretrial release if the burden has been met. So I think in order to fairly and accurately determine whether the burden has been established, it would need to be done at a hearing where both sides have an opportunity to present and rebut. And I think if we really want to give full effect to that burden that's, expressly contained in Section 14, it would have to be done at a hearing that, where both sides can adequately present and prepare evidence. Now, that state is not suggesting it can't, invariably be done at first appearance. It may, but I think the majority of this court is familiar with essentially the realities of what happens at first appearance and how they generally are conducted. First appearance.
Mr. Ali, is it the state's position that when the first section of when the first sentence of Section 14 refers to proof evident presumption great, what is being presumed is guilt?
That's now the text itself doesn't refer to it, but this court has this court in several opinions prior to and subsequent to Arthur has held it does refer to guilt.
It's interesting that you say that. I'm familiar with just one case from 1956 of this court saying something like that. I wonder, what is the status of the presumption of innocence in the state's view after a successful Arthur hearing? Has it been rebutted?
I don't think detention pending a trial in very limited circumstances necessarily implicate or infringe upon the presumption of innocence. I think in this narrowly circumscribed situation where there's a very, very narrow class of defendants who may be detained prior to and pending their trial necessarily infringes upon the presumption of innocence. I don't think it rebuts it. The proof evident presumption great, it's understood in different jurisdictions, with varying burdens of proofs. In Florida, it's understood to be a burden of proof that's higher than beyond a reasonable doubt, what's necessary to sustain a criminal conviction. But as far as Your Honor's question, I don't think it's certainly not rebutted in the context of a trial that would be ensuing.
Well, I guess it goes to what you were discussing, which is the burden, right? Like if the proof evident presumption great standard is higher than proof beyond a reasonable doubt, then it would be the state's position that at the Arthur hearing, it would need to do more than it would have to do, that the state would have to do a trial to get a conviction. Is that accurate?
As it's understood in Florida, that's generally, that could be a fair statement. I think what that burden gets at is it's sort of terms of art, but I think it tries to express as a protective barrier against a defendant, because someone who hasn't been found guilty, obviously, and is being detained prior to trial, I think that is certainly something of concern.
Well, but I don't want to get things confused. Clearly, there's a second sentence to Section 14 that talks about risk of flight, danger to the community, forward-looking determinations that can be made. I'm focused for the moment on the first sentence, where if the state is to sustain its burden, then it would seem that what the state is now arguing is it needs to meet at the Arthur hearing a higher standard of proof as to the removal of the presumption of innocence than it must at the conclusion of trial. Is that the state's position?
I would answer yes, but qualify it, Your Honor. And I think in this context, I don't think we're necessarily, I think, comparing them completely in similar terms. I think this burden of proof, it's been understood to be, more than necessary to sustain a criminal conviction. That's what this court has held, and that's what it has previously stated before and after Arthur. But I don't think that it's completely analogous where it's, we would necessarily have to present more evidence than what's necessary to carry a criminal conviction. I think what it's reasonably understood to mean is that, this has to be something more than probable cause, which is obviously a lower standard than, necessary for a criminal conviction. I think it would have to be significantly higher than probable cause, and it would have to, I think, assure the judge in this case, in all cases, that there is a reasonable, possibility that this person may have done it. So I don't.
Why shouldn't the state then have to make a motion at initial appearance for pretrial detention? Why not require the state to do that?
Well, I think the fact that when Section 14 was amended in 1983, I think the pretrial detention exceptions, they address a different category of concern of defendants, concerns that may exist. And I think the two exceptions, they exist differently. There is some overlap, and there will be overlap on many occasions, but I think they're each address different categories of defendants. So I don't think that the state is required by virtue of the second exception to file a motion for pretrial detention. I think reading the Section 14 as a whole, I don't think that we necessarily need to supplant the first exception or sort of go around it by using the second exception invariably on every occasion. I think to give full effect to both exceptions, the state should be entitled to proceed under either exception, when applicable.
I think in fairness to the state, some homicides may occur, let's say it happens around 2 a.m, and the person gets booked in the county jail, from the scene at 3 a.m, and that person may be coming to first appearances at 8 o'clock. The state is not going to have the opportunity to prepare a proper motion for pretrial release in that period of time. It may, like I said earlier, he may ask for more time the next day. By that time, it should be ready. But and things happen that way sometimes.
I agree, Judge. I think in every case it's going to be different. But as Your Honor just mentioned, that's a common occurrence that may certainly happen. And if that were to happen, I think both the state would not necessarily have the time to marshal this evidence, and nor would the defense have time to possibly rebut it before having the right to pretrial release removed. So I think that's an important factor to consider is interpreting this provision, the first exception, the capital or life offense exception, in a reasonable manner to allow both the state as well as the defendant to attempt to either fairly establish or try to rebut this burden of proof doesn't prevent a trial court from setting the hearing off, temporarily detaining this defendant, deferring ruling on the entitlement to pretrial release, until both sides are given a sufficient opportunity. And I think this case, the facts of this case pose a very good example of both sides being provided with such an opportunity. And just as an initial matter, I want to clarify Mr. Thourtman's position. He wasn't held in custody for a month waiting for an author hearing. He requested an author hearing. The moment he did, the trial court suggested that it occur that following Monday. The record reflects that, and because of scheduling issues, it was held 4 working days after he requested it. At first appearance, he didn't, he didn't request any type of author hearing or signal to the court that he wanted to have a hearing. But I think this case is a good example of during the author hearing. In this case, both sides were able to, the state was able to present evidence, and I think very importantly, Mr. Thourtman's counsel was able to, cross-examine the state's primary witness, recross him again, and present sufficient argument to the court. And I think that's a very important consideration in why the proof evident presumption of great burden wasn't met as to him possessing a firearm during the offense.
Mr. Ali, if there is a problem, is that problem that we don't have a procedural rule that outlines what a reasonable time is within which to hold this hearing, or how the state indicates that it wants to use this provision to hold a defendant?
I think it may pose some concerns, Justice Lawson, but I would point out that after author's decision, I mean, this procedure has been sort of existing for 40 years and it hasn't come across this court's desk. But whether a procedural rule would benefit both sides, it's possible. I think that may be something directed to the applicable rules committee.
If we did have a procedure, would it make sense to provide for a probable cause determination as to whether the state could meet the higher standard of proof evident presumption great at a hearing at the initial appearance?
Well, absolutely. I would think the state would need to. They would be required to, just to hold the defendant, because without that determination, there is no justification for holding the defendant without a probable cause determination. So I think that should that rule be enacted, there should be a requirement, obviously, that probable cause be established, prior to this proof evident presumption great determination being made.
But Justice Lawson's question, I thought, was more, should there almost be is there probable cause to believe that standard will be able to be met initially, right away? Isn't that what you were asking?
Yes, it is.
Yes. I think along the same lines that would adequately address, I think, both sides' concerns, and there should be probable cause to believe that, this burden may be established at a later date. I think that's fair. And if this court has no other questions, we would ask to affirm the decision of the Third District Court of Appeal. Thank you.
Rebuttal.
Thank you, Your Honor. May it please the court. I want to first address the state's position that the issue is undetermined, or in the states later use the word that the ruling is deferred. That is why we have presumptions. The entire issue here is the presumption of innocence. And in Arthur, before Arthur, it was the presumption of guilt. And those all work together. If there's a presumption of innocence, then the burden is on the state, and then the custody decision is release on reasonable conditions of pretrial release, whatever those may be in the situation. If the presumption is guilt, then the burden is on the defense, and you stay in custody. The state's proposal that the question is undetermined requires the court to fall back on the presumptions. And the presumption is innocence, unless the state's position really is that Arthur is wrong and should be reversed, and I don't hear the state making that argument. So fundamentally, I think that answers the state's position.
Mr. Morrison, can I ask you, do you think it would be violative of the statute if if the judge made a probable cause determination that this standard could be met, and that would be the basis for holding the defendant for a reasonable amount of time until an author hearing could be held?
Yes, I do, Your Honor. The plain language is unless crime chargeable by life or death, and proof is evident, presumption is great, unless the state has already met its burden. So probable cause, that would be a very deliberate watering down of that constitutional standard.
Your position is that any procedure that allows a reasonable amount of time to hold the Arthur hearing would be violative of the statute?
No, Your Honor. My position is that holding the defendant without bond until and unless the state meets the standard is violative. And
okay, so I mean, I'm back to, I mean, if that really is what the statute means, then how can you have someone incarcerated prior to initial appearance without bond?
Your Honor, that goes back to my earlier answer. That is an executive function. Arrest.
The statute say that, I mean, incarceration is controlled by the executive. So I mean, this is talking about what the executive does with a person until they can have their day in court, essentially. So I don't understand that as a distinction under this statute.
Your Honor, I believe that Article 1, Section 14 deals with right to pretrial release. That is a judicial decision. That is not an executive decision. That is not the police officers. That's not the booking. That's not anything. The judicial decision starts at first appearance, hence the name. It's at that point.
Well, it starts at first appearance because we don't have another procedure in place for the author determination. I mean, it doesn't have to start at first appearance, right? I mean, if we had a procedure that had a different time, then the defendant would be held without bond until that hearing, right?
Your Honor, I believe the first appearance is necessarily just what it says, the first time a person appears before a court. And then the court is bound by the constitutional language, the plain constitutional language, unless the state has met its burden. It may not, the judge must impose reasonable conditions. I'm out of time. I thank you for your consideration, unless anybody has any additional questions. Seeing none, thank you.
Thank you. We thank both of you for your arguments, and the court will now prepare to take up the second case on today's docket.